Yes. Isaac Vernon Williams II.
All right. Okay, what are we doing on this case today?
Your Honor, I've had an opportunity to talk to Mr. Williams, and there are a few things. First, he would like to represent himself, but he has no problem with me staying on to assist him. I also think that he needs to be
Correction,
referred
please.
for competency
Correction.
and criminal responsibility.
Your Honor,
So
I have
you believe that there should be a referral?
Yes, Your Honor.
Your Honor, I have indicated that there has been a referral and that this obviously would be an independent and an additional second referral for competency and criminal responsibility. There was a finding of competency May 26th. I know that when Mr. Feaster was previously counseled, there was some consideration based on some statements on the record. And Mr. Williams claims that he would like to proceed self-representation, that they may pursue an additional referral. And then Mr. Williams did refuse to participate in the criminal responsibility evaluation as well. I have nothing to provide the court to really object on the record to preserve, this record for appeal. So I'll defer to Your Honor.
And
Your Honor, to please the court, may I speak to?
Right here, Judge Woodard sets the tone. When a judge pauses the courtroom and reminds everyone about decorum, that's not just about manners, it's about control. Courts run on order, and whoever can't control themselves instantly loses credibility. Let me ask you this. When emotions run high, should family disputes even be handled without legal boundaries in place?
The court?
Not right this second. Just hold one moment, Mr. Williams. I know you'll get in what you need to get in. Miss Woodson?
Yes, Your Honor.
Have you begun the process of an IME?
No, I haven't, Your Honor. I do have someone I would like to contact to conduct the IME.
And so that typically is being done through, I think, the Office of Manager Assigned Counsel. So you have not begun that part of the process, although you may have a name.
No, Your Honor. I was going to just have him referred. It wasn't until I was speaking with sister counsel yesterday that I found out that he had been previously been referred. So yes, I will begin the process of.
Yes, gotcha. Okay. All right, Mr. Williams. What do you?
Yes, Your Honor. I want to bring to the court that I wish taking stand full purpose honor. I do not wish an assistant in any behalf unless it's going to be Jesus Christ, because God has to go forth and stand as my own attorney, and he had made it plain unto me that he will give me what to say before the court. So therefore, I wish to go before the court, pro persona, my own defense. I do not wish anyone to represent me as a co-defendant attorney. So the young lady, she was incorrect. I tried to correct that when she made that statement. I do not wish her help unless it's Jesus Christ. Otherwise, I don't need her help on this matter. I am going forth before myself, on behalf of myself. And I wish the court would take and get an order to the Washington County administration to get me before the court in my body, before the court, to take and find a motion for an evidentiary hearing. That's the first thing I want to do, is get an evidentiary hearing. I've been trying to also get before the court a motion, you understand, for the discovery. I have yet to get a copy of the motion for discovery before the court. They told me I should send that to the Attorney General. So I sent it to the prosecuting attorney here in Washington. Then they took and sent it back to me and told me it should go to the Attorney General. So that needs to be corrected, and I will get a copy to the Attorney General for a motion for discovery, because I would like.
This is the moment everything shifts. Leaving a 6-year-old in extreme heat with no AC, limited food, and supervision? Legally, that can cross from bad judgment into neglect. Judges don't rule on intentions, they rule on a risk. Do you think 2 hours is no big deal, or is this where parental responsibility becomes non-negotiable?
Get that motion for discovery to start, you understand, making preparation for my defense. I am going to stand pro per persona before me, before the court, and I want to be in the courtroom. So if you ever want to hear my voice again or see my face again, get an order for me to be before the court. Thank you. The peace of God be with you and your family. Have a blessed day. Thank you.
All right.
Well, okay.
Oh, he was done.
That's probably just as well, Your Honor.
I guess he finished his speech.
And Your Honor, we've gone through this so many times already on the record before. Ms. Wilson came well thought through at this point, at least to make sure that we're proceeding in the way that we need to proceed. So
all right.
I will say that as far as if the court does make certain determinations, you did indicate you would keep this, if this does proceed to exam, you would keep this.
Yeah, but I'm
additionally,
thinking about that again, but go ahead. Yeah.
And I would ask that Sister Counsel, I mean, whatever he ends up determining, there are multiple witnesses here that are alleged victims of Mr. Williams, violent victims of Mr. Williams. And so I am going to be asking whatever determinations the court makes, that Sister Counsel be the one to question those particular witnesses. There is an abundance of case law on that matter. And so obviously we need to get through the first step on this. I did make sure I sent Ms. Woodson the original competency report yesterday, so she has that, and we'll go from there.
All right. First thing is regarding the IME. As I listened to the defendant today and his basis for wanting to represent himself, although I don't think he needs a basis, but as I listened to it.
And here's the legal reality check. Child support isn't a punishment, it's an obligation. Income, duration of care, and financial contribution all matter, and the court is crystal clear. You don't get to opt out just because family stepped in. This ruling isn't about pork chops, it's about accountability. Do you agree with the judge's final call?
The court has some concerns, and this court has concerns as to whether or not he is even in a position at this point to be able to make such a decision. And so I would need to have, or at least see the result of that IME prior to that determination being made as to whether or not he could even represent himself in this case, or making a decision on that, because I don't think his argument regarding that was very cogent, at least from the court standpoint. So what I will do at this point, Woodson, you are going to begin that process.
Yes, I was going to ask if the court would consider a re-referral, but if I think an IME might be a little faster. I know he's been detained for quite some time.
Okay.
Yeah.
Well, yeah. All right. So give me 60 days out. So on the belief, and I think it would be something that you should do in terms of the IME. I just set, you said the 20th.
Yes.
I'll set a competency hearing, another competency hearing for November 20th, 2022. October 20th, 60 days out. Okay, it's only October, 60 days out. I'm already in September. October 20th.
That's good.
2022. Yes.
Thank you, Your Honor.
Along at that time, and his bond will continue as denied, and then I'm just going to defer any other rulings until we can get a grasp on that issue, because I don't think it makes any sense to rule on anything at this point. All right.
Thank you, Judge.
Thank you, Your Honor.